Hey, Elder Law Care Warriors, Elder Law Care Attorney Patrick Kelleher, coming to you from elderlawcare.com. Folks, today's question, hey Patrick, what are the benefits and maybe what are the detriments of a testamentary trust? I'm not a huge fan of testamentary trust because the word testamentary means after death. And the biggest detriment of a testamentary trust in most cases will end up in probate court because typically testamentary trusts are created in a will-centered plan. And remember, a will is your admission ticket to probate court. So let's talk about, from my experience, the three contexts or areas of estate planning in elder law where I see and observe the use of testamentary trust, typically in the context of folks who are incapacitated or disabled individuals, such as elderly and folks who are diagnosed with some type of incapacity or disability like a special needs. Typically, the testamentary trust is created within a will-centered plan, but not always. Sometimes a testamentary trust can also be created within a trust-centered plan. Bill and Mary come in to create their trust, for example. They have an adult special needs child. I would advise them, do not give a direct inheritance to your special needs child. Why? Because that will put them over asset for their means tested public benefits. Typically the cutoff is $2,000. If they receive their inheritance either directly in a will or a trust, outright distribution free of trust, that's going to immediately put them over asset over that $2,000. If they inherit, say, for example, 100,000, now they're 100,000 over asset. What's going to happen? Big detriment. They're going to lose their government benefits because they're going to be over asset. That can be catastrophic for a special needs person. They could lose their housing in this case. Housing, medical insurance, food, shelter, all the necessities, needs-based care that the government is currently providing. So in comes the testamentary trust for that third-party special needs trust created within Bill and Mary's general trust, right? A subtrust, we'll call it. But Bill and Mary can earmark, say, life insurance, maybe a piece of the house, a portion of the house, maybe a portion of their IRA. Say Bill and Mary have 4 children. One of the children, say Curly, special needs. They want Curly to get 25% of that IRA. They create the third-party special needs trust within their trust. That's a smart move. But now they need to go the extra step. Step 1 is designing and signing the trust. Step 2 is getting your treasure in the treasure chest. So they want to work with an experienced, qualified elder law attorney to make sure that testamentary trust is named as a beneficiary for the 25% share of their IRA. So the monies will be payable upon their death to the trustee of Curly's third-party supplemental needs trust, which is a testamentary trust. If they did not update the beneficiary designation, it would go off to probate court. Or even worse, potentially, if Curly was named individually and not his third-party supplemental needs trust, then Curly's going to get the money. It'll avoid probate, but what is it going to do? It's going to put him over asset, and he'll lose, again, his government benefits. So you need to name the trust, the third-party supplemental needs trust, as the beneficiary to avoid both probate court, but also to avoid the fourth-headed monster, which is Medicaid. Other contexts I see it being used is maybe for minor children. Young couple comes in, they have minor children. If they do not have the budget to create a comprehensive trust-centered plan, they can create a will-centered plan with testamentary trust created for their minor children. The downside to that, it will go to probate court typically unless you can have the financial company also name the trustee of the testamentary trust as the beneficiary. I would recommend try that approach to look to avoid probate court. It can come in handy in that case as well. Another context that elder law attorneys often see as a strategy is creating what they call a Medicaid will. Medicaid will is designed to protect the home from Medicaid. Under federal Medicaid laws, you can create a Medicaid will with a testamentary trust. And then oftentimes I'll see the deed to the property, the asset they're looking to protect. They'll change the deed to the property rather than Bill and Mary holding it jointly. The elder law attorney typically changes that deed to what they call tenants in common, which doesn't look like a good move initially because tenants in common will put the property in probate. So say Bill's in the nursing home. They create a Medicaid will with a testamentary trust. They change the deed to tenants in common. Mary dies first. We want Mary's 50% share to go into the testamentary trust. But The will, being a mission ticket to probate court, is first going to put that property into probate court, which is not ideal. And then Mary's 50% of the property would go into the testamentary trust. Think of the testamentary trust like a firewall. It's going to protect the property from going to Bill in the nursing home. Say Bill dies a week later, his 50% share will also go to probate court, and that's not ideal. However, Medicaid rule, the 50% that Bill owns will now be protected from Medicaid because Bill's 50% share will also now legally be transferred or funded into that testamentary trust. In the context of a Medicaid will with a testamentary trust, it has been shown to be an effective tool to protect from Medicaid. We typically reserve that type of Medicaid will with testamentary trust reserved for crisis planning if there's a spouse in very poor health and typically already in a nursing home, and you have the other spouse as the caregiver living in the community. She's doing better, but sometimes you don't know who's going to die first. Medicaid will with testamentary trust could work in that situation. It's a good fallback strategy. So folks, there you have it. That's my opinion on testamentary trust. Folks, thanks for tuning in today at elderlawcare.com. Make sure you subscribe, click the notification bell, share this video. Thanks for joining us here today.